Using my voice today. Good morning, Facebook, Instagram, YouTube. Um, say hi in the comments. Let us know where you're tuning in from. If this is your first time tuning in, definitely say hi. Subscribe to my channel on YouTube, on Facebook, and on Instagram. Guys, I'm trying to get to 10,000 followers on Facebook. We're so close. Share my video, share this. If you find this video helpful, don't keep it to yourself. You never know which one of your friends or family might need this. Amnesty says first time. Good morning. Good morning, Yemi from Indiana. Good morning, it's Muda. Um, good morning, Anne from Boston. Good morning. Oh, it's Mula. This is your first time as well. Good morning, Sherry K from YouTube. I'm like butchering you guys' names. As I was saying, you guys, I'm struggling today with my voice. Like I feel like I woke up with a frog in my voice. So let's see how long I can talk for without having to disconnect. Let me introduce myself. My name is Aisha Chidole. I'm an immigration attorney here in Florida, and we have offices in Atlanta. I represent clients in all 50 states and internationally with their immigration matters. I'll be happy to assist you or your friends. My phone number is 407-995-6567, or you can send a WhatsApp 404-333-8751. So let's just get right into it. So today I want to talk about the dreaded denial of your green card and what your options are. I'm really going to focus on green cards based on marriage in my topic today. So there are very many different reasons why people get denied. And so the answer or the strategy, of course, as any lawyer will tell you, will really depend on what the reason for the denial is. But I'm just going to talk about a few different things. So, you can, let's say you get a denial for little petty, ridiculous stuff like, you didn't submit, your spouse did not either submit a like you didn't submit a joint sponsor, you needed one, or you didn't submit enough information to show that your spouse meets the income requirement to petition for you. Those ones are really relatively simple denials that you can either just file an appeal or you can reapply. So it just really depends on what is approved. So I always take different strategies for situations like that. So if, let's say, your I-130 was already approved, how is it that I'm already on 20% battery life? All right, guys, hold on. Let me just find my charger because I'm about to lose you guys on Instagram. Hold on, guys. Stand by. Let me just plug my charger. I was listening to music this morning. I listen to music every morning when I'm getting dressed. I love listening to gospel music to get my day started, and I think I overdid it. Okay, guys, on Facebook, hold on. Let me just charge my phone before it gets disconnected. And for those of you wondering if this is your first time, I have like my computer and my phone because I go live on different platforms. So that's why I'm looking up and down. So as I was saying, if you get denied because, let's say you didn't submit like your joint sponsor, or, your spouse didn't, meet the income requirement, or basically something related to financial affidavit of support, but your I-130 was approved strategically, I might just say, what, submit a new adjustment of status application with the approved I-130, right? If the I-130 wasn't approved, the 485, then you can certainly do, an appeal. The reason why I say submit the 485 is it depends on where the client is and, their need to work, because, sometimes an appeal can take 8 months, before they even consider do a motion to reconsider, and then open it and then review that, and then possibly reschedule you for an interview, versus if you just do an adjustment of status application with the approved I-130, you'll probably get your work permit within that 5 to 8 months, so at least you can work and then just go for your interview. But then if you get a denial based on you lack sufficient bona fides or sufficient evidence to show that your marriage is real. This is a very serious denial, and I want you guys to take it very seriously. So, marriage fraud can be worded many ways. And sometimes they may not necessarily say your marriage is fraudulent, but they can skirt around it in certain things that they say. So, it's one of those things that I have to read it to determine how bad it is, what it is they're saying. Most people, in order for you to get this kind of denial, you should already know it's coming because you would have either received a notice of intent to deny with all the potential issues that you have. So when you get this decision that's denying you, it's because you were not able to overcome all the discrepancies in that. So if you get one where they're basically saying your marriage is not legitimate, or they feel your marriage is a sham, do not let that go. Are you guys listening to me? Do not let that go, because if you think, I'm just gonna just divorce this person and then I'm gonna remarry somebody else, and then you guys have like 5 kids later and you try to apply, they don't care about that new marriage. They're gonna go back to that marriage and they're gonna say, you know what? You had a fraudulent marriage with that one. So unless you can show us that that marriage wasn't fraudulent, we're not even going to approve you for this one. So, this is something that you must appeal or you must file again. You must appeal or you must file your application again with that same spouse. I'll talk about the exception. So if, let's say, you get that, you and that spouse better file again, and you guys better provide more bona fides, or of course, if you're no longer with the spouse, whatever it is, then you have the two options, which is, you can file for appeal based on the information that you had at the time you submitted it to show that your marriage is in fact legitimate. Or if you qualify to self-petition, that is also another opportunity for you to show that your marriage is legitimate. So, a lot of times, we may have a client that has, and I'm talking about clients who come to us for VAR cases, which is cases based on abusive behavior by their spouses. We might have a spouse who it reads as though the person has a non-legitimate marriage or a fraudulent marriage, but it's the intention of that abusive spouse to make it look that way. So when we evaluate it and when we see the records, we're able to say, no, this person did this intentionally, and here is the fact, bang, 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 to show that this person did it intentionally. And then you can submit a valid petition. So those are the core 3 things that you can technically do if you're denied, which is either appeal, either file again, or if you qualify for VAWA, submit a VAWA claim. And then, sometimes you might have, I want to talk real quick. I'm going to segue. I'm going to get back to you guys on your questions. But that's it about that. I just want to talk about an email that I got this morning because I'm just so happy, for this client. I have a client who, basically this client hired me for something like to help, petition for their child because they had already petitioned for themselves pro se like 3.5 years ago. So they were just waiting on their own petition, and they try to reach out to USCIS. USCIS, nobody was responding to them for like 3.5 years. They reached out to a different lawyer. The different lawyer couldn't get USCIS to move, and then we did an ombudsman request, and then we got you. And so this client actually had a Stokes interview that went terrible. Like a Stokes interview, for those of you who don't know, is when they separate the two of you. And when you go pro se means that you don't go with the lawyer. You really don't know what to expect. And, like it was just, basically bad. So, ombudsman eventually, scheduled them for an interview. And, I was like, listen, you guys, we got to go gun blazing. You cannot go into this interview, not prepared, So, of course, I knew that they were going to get a Stokes interview again. We did the Stokes interview. They went to the Stokes interview. I think they did well in the Stokes interview. And then, our client had to get his medicals because, one of the requirements now, because the medical, was obviously expired, but then the client had to get his medical. We received an RFE because the client had to get his medical and provide more bona fides. And while we're trying to gather this information and this request for evidence and submit this medical and submit more bona fides, our clients get called again for the third interview. And, of course, this time they literally didn't know. So before the interview, we prepared the client, stacked out the evidence. Client just submitted the evidence. And I just got the email that the client was approved for their green card. So I'm super excited about that. So you guys, never give up. Never give up. If you have a legitimate marriage and USCIS doesn't want you to be great, don't give up. Delay is not denial. You just have to keep going. You need to be with, you need to go with an attorney who, is a zealous advocate, whether it's me or whoever you use. You want to make sure that your success is important to your attorney. I always say to, my clients, I know, I'm very busy, and so I can't be in 20 different places at the same time. But no matter how big I am, I always want to go over every page of my client submission before it's submitted, because I want to make sure that we have a strong chance of winning. Anyway, so I'm done with that excitement. So let me answer those questions on here. America Tax Attorney, thank you. Boo for the Boolas. Good morning, Vawa Queen. Good to meet you on live today. I know I haven't seen you in a long time. Ismula says pin your number. Okay, I learned how to pin my number yesterday, so let me just type it. But for those of you who don't know, it's 407-995-6567. Okay, let's see. So do I post it first? I think I post it first before I pin it. All right, guys, just give me a second. Let me see if I can remember it. Okay, so tell me if you can see my pin on there. Okay, somebody says, if you got denied because your spouse refused to show up for the interview and divorced afterwards, how'd you go about that? So Jay, that is a really good question. And that's one of those, the answer to that is one of the examples that I gave where, in that case, we want to definitely do an evaluation to see if your spouse is abusive towards you, because to me, if you're married to somebody, and I say that as somebody who is married, who has been married for I think we're going on 13 years this year, like I don't care like how pissed off my husband makes me, but something as important as his green card and him being in this country or being able to be with his children or his family, or to be able to provide for his family, like we could have had the biggest fight of our lives, but I will be at that interview and he will get his green card. So to me, any spouse that doesn't show up to an interview is a red flag, so it's one of those that we definitely need to evaluate to see what the dynamics are in the relationship. Why didn't that person show up? And a lot of times you will find a pattern of abusive behavior. Not all the times, but a lot of times you'll find that behavior. So it's one of those that you definitely want to get evaluated. And then if you qualify for VAWA, you can definitely self-petition. If you know in advance that your spouse is not coming and your spouse has already told you that they're not coming, one of the things that your attorney can do is, well, if you hire me, is that we can send an abeyance letter to USCIS or give you one to take with you, just so that they won't deny your case outright. That way you can at least keep your work permit so that you can prepare a VAWA petition, or at least see what your options are there. Okay, let's see. Okay, let me take someone Instagram. On Facebook. Good morning, Brandon. Good morning, Hondo. It says good morning, Happy New Year. I have a friend of mine who's married to someone from the USA. She's filing for her taxes and wants to put her husband on the file, and the tax lady told her she can't do it. She has to wait until his paperwork is filed. Is that true? Well, I can't answer the question because I'm not a tax attorney, so I don't know on what basis the tax attorney is, the tax person is telling them they can't do it. But if the question is, do immigrants who don't have their green cards file for taxes, yeah, they do. So I don't know what that tax person is saying, but definitely try and get a second opinion, or get some clarification, or ask your friend to get some clarification, unless the person doesn't have a social security number or an ITIN number. So that could be, but again, I'm not a tax person, so I can't really answer that. Minaj says, good morning. How are the family doing? Everybody is wonderful and healthy. Thank you. Is my mouse dead? I can't even scroll through. Okay, let's see. Arhan on YouTube says, "Good morning. How long after you submit an application should you receive your receipt notice?" So the answer really depends on what kind of petition that you submitted. So it will vary depending on, one, what the processing center is. But most receipt notices take anywhere from 3 to 6 weeks. Last in the height of COVID, we were seeing like some like that takes 8 weeks. But knock on wood, usually if you haven't received a receipt by 6 to 8 weeks, it typically means one of two things. You can confirm if the package was delivered. First of all, nothing should ever be sent to USCIS without a tracking so that you have your record. That's number one. And number two, um, usually, because we do tracking. So if we've still not received a receipt, then that means there's something that's causing that packet to be rejected, and they're going to be sending it back to you with the reason why it was rejected. Sometimes it's USCIS error, sometimes it's something that you might have missed. I'll give you an example of something that one time when we got a packet back. I think that, we human beings will make mistakes. I think I wrote on the check 2021 or something, like 2020 or something. Basically, the year was the wrong year, and they sent it back. I was like, these people are so petty, because clearly the timeline has passed, but they could still have cashed it, but they sent it back. So, it just really depends. Good morning, Cecilia. Good morning, Andrea. Good morning, Mood Star. Okay, let me see what this question is saying. What if you got divorced in August of 2019 without your knowledge? Would you still be qualified for VAWA? 2020-2021. No, you're no longer going to be qualified for VAWA. So in order for you to file a VAWA petition based on divorce, after divorce, the divorce has to have been finalized um, within 2 years of submission. But yours would have been 2 years in August of last year, so you're a couple of months late. What some people have been able to do, and that's something that you might want to try and do, is you might be able to reach out to a family attorney. Like, I know that we've had clients, not a lot, but some clients in a similar situation where the divorce attorney were able to reactivate the divorce, based on it being like either like fraudulently done, or no proof of service or whatever, if they can find something. But usually that's very state specific, so it depends on your state and what the requirement is for your state. Okay. Okay, so Boo for the Booless, that is a very good question. He says it takes 2.5 years for a valid process. Will the 1 year of the pending I-130 count, or the VAWA will start a fresh counting? Unfortunately, the VAWA will start a fresh counting because it's a completely different application. However, if you do have an approved I-130, and let's say you're submitting a VAWA petition and you don't have any of the evidence that was initially submitted, having that approved I-130 is a good evidence to add to show a bona fide marriage with your VAWA petition. So Ms. Mimsy says, how can I contact USCIS over the phone? It's really hard to get to speak to a customer representative. Yeah, they do that by design. Like, they really are not trying to, it's like Fort Knox, like you really can't get through. One of the things that I would recommend is you call super early in the morning and you just keep saying InfoPass, and you do not stop saying InfoPass until they tell you that they're going to be transferring you to somebody. And then when they transfer you to somebody, then you can discuss your problem. Can we file for a green card removal of conditions without joint tax filing? Ash Kayam, yes, you can. However, you really need to have strong bona fides. If this is not your first time, I talk about this all the time. Conditional green cards, the requirements are much harder to remove the conditions on your green card than just getting a green card for the first time. When you're getting a green card for the first time, it is logical that a lot of things you might not have. One, because you've not been married that long. Two, you didn't have your paperwork, right? You didn't have your social security number. You may not have had a work permit. You may not have had things for you guys to really acquire. You may not have had those opportunities. But when you've been a green card holder for 2 years, the expectation is greater. What they require of you is greater. So you want to make sure if you're a conditional green card holder, that you continue to accrue evidence. They are going to be looking at evidence from the time you became a conditional green card holder. So you can't go giving them stuff that you gave them for your initial approval. So if you're not filing taxes, better have a good reason and some other strong stuff. I mean, we've had clients certainly get approved without filing joint taxes together. In fact, we had one where they came to us, they filed themselves. They got a notice of intent to deny. It was very hairy and very, in fact, sometimes I surprised myself, we got this client approved, but we were able to show that the reason why they didn't file taxes together, well, this is one of many, many discrepancies, but I'm just talking about the specific taxes, was because that particular person owed a lot of money because of, whatever financial commitments or his business and stuff like that. And so it didn't make sense for the spouse to file with them, because then she will also be included in the people that owe taxes, because in the United States, when you file jointly, both of you are jointly responsible. If one person can't pay, they're coming after the other person, and that, in addition to being able to answer the other, we're able to overcome the notice of intent to deny. When can I contact your office based on my case scenario? I don't know what your case scenario, but you can call us right now. We're here. We're open from, I want to say, we can take your calls from 8 to 12 midnight Eastern Standard Time. There will always be somebody that's available to take your call and schedule you for consultation. Dreezy says, got annoyed for my case on the basis of my previous divorce docs not being valid, and I should prove for my current marriage is valid. I resubmitted further proof and waiting on USCIS update. Dreezy, where are you from? If you're from Nigeria, this is a big issue with Nigerian divorce cases. A lot of Nigerian divorce decrees are not authentic, or USCIS doesn't believe they're authentic. So you want to make sure, one, that your divorce is authentic. You want to make sure that you're using an attorney if you're from Nigeria, because first of all, in Nigeria, you should be using an attorney, because that is the requirement to file for your divorce. That's number one. You should have a divorce nisi and a decree nisi. If you have children, your children should be mentioned and their custody agreement and those divorce, So if you get a divorce and you give a sheet of paper that doesn't talk about your children, that's a red flag for USCIS, So, it's just really important to make sure that you're not just, go do a divorce for me, and not really paying attention whether it's serious or not, because it will affect you, and you being able to marry. Now, if you and your ex-spouse are in the United States, you can certainly just do the divorce again properly and explain the reason why, or why it was out of your control that the divorce wasn't valid, and then remarry your new spouse. PD Solution says USCIS asked the petitioner to withdraw the I-130 because there are some discrepancies which they refuse to mention, and they asked the petitioner not to let the beneficiary aware of withdrawing. Where is this happening? Is this Indiana? I'm seeing that happening in Indiana field office a lot. Can you confirm for me, PD Solution, if that's what it is? That's not good. That's a potential issue, and this is why you need a lawyer. Because if you were going with a lawyer, your lawyer should be advocating for you and say, no, you cannot do that. Your lawyer should say, no, you're not going to sign that, and stuff like that. Okay. Can someone file for a work permit after marriage and file for a green card later? No. In order for you to file for, okay, let me clarify that. In order for you to file for a work permit, you need an underlying petition. An underlying petition in this case would be your green card petition. So you have to file the green card petition. What if you, I answered that one already. Guys, there's so many questions, so I can't even see, I might be missing some. I have only 5 more minutes. How long does it take to get an EAD after you file for VAWA? Well, there are 2 types of EADs you can get with VAWA cases. The first one is because your case is pending. The second one is because your VAWA case has been approved. The work permit that you get because your VAWA case is approved comes, within 2 years, really 18 months to 2.5 years. It could vary, that's one. And then the second one is, what am I trying to say? I've lost my train of thought. One of my staff just sent me a message and it just completely distracted me. Let me read your question again, please. How long does it take to get an EAD? Oh yeah, so the second one is if you submit and use the right category, based on your pending 485, then you can get your work permit anywhere from 5 to 9 months. That's what we're seeing right now. Most people fall within the middle of 6 to 7 months, but that's the window. Okay. Deja Vu says, me and my wife have been divorced since May last year. I'm still expecting the I-130 to be approved. Can we get divorced or wait? So are you divorced or you're not divorced? You know, because you're going to be denied, or they're going to basically say that you were incorrectly given that green card if you're divorced. So, you know, and I would not, like, anyway, there's a whole lot going on and it's one of those that, we need to discuss. If you got denied, I answered that one. Sorry guys, I know that I'm missing some people's questions. Let me go to YouTube because I'm rejecting my YouTubers. Okay, this is my last question because I think I've run out of time. Good morning. Me and my husband put in my son's paperwork. Then we went for a marriage interview. May my son get approved from October, and I'm still waiting to get approved. So I send back for a new work permit, and I'm not sure I understand your question, Samantha. Are you asking why your son got approved before you? If that is the question, the answer is that it could happen. It just depends on, who the officers that's reviewing both of your cases are. You might have one officer that's quicker or doesn't have a large caseload. You might have another that has a large caseload. And so that is probably why. But hopefully you get your approval soon. Okay, guys, I gotta jump off. What time am I gonna come? I have an interview tomorrow morning. It's gonna be telephonic. Wish my clients luck. This is also a really tough case. I don't know why you guys keep coming to me with tough cases. I want to be getting easy cases. So I might come on live like around 11 tomorrow, after my interview. I may. All right, guys. But normally, for those of you just tuning in for the first time, I normally come live sometime between 9 to 10 a.m., somewhere in that window. So if you subscribe to my channel on YouTube, hit the notification button on Instagram and Facebook, you'll see or know when I come live, or you can always catch it, after I've come on. And again, guys, I'm really begging you. I want to get to 10,000 followers on Facebook. I'm very, very close. Share my post, share this live video so your friends can follow me. All right, guys, I'll talk to you later. Bye.